Hello, everyone. Welcome to Real Estate Principles Unit 1, the business of real estate. I am your professor, Professor Jay, be leading you through this unit. And I'll pull my video feed away so that I can give us the entire lecture going forward. Thank you so much, and we'll see you at the end of the video. Learning objectives. When you have completed this unit, you will be able to accomplish the following. Describe the functions of the Department of Real Estate and the Real Estate Commissioner. Identify the ways in which real estate brokerage may be owned. List the allowed activities of a real estate broker and salesperson. Describe what might be included in a business opportunity transaction. List the requirements for a prepaid rental listing service. List the requirements to become a real estate broker or real estate salesperson. Describe how the real estate law is enforced. Identify the types of prohibited conduct that can result in disciplinary action. Explain the purpose and funding of the education and research account. The real estate law. Over a century ago, buyers had few protections from unscrupulous sellers and real estate agents. Instead, the common law doctrine of caveat emptor, a Latin phrase meaning let the buyer beware, prevailed. The state's police power allows it to license real estate agents. In 1917, California became the first state to legislate licensing requirements for real estate brokers and salespersons. Although that initial legislation was declared unconstitutional, it was quickly amended, and the California Supreme Court upheld the subsequent Real Estate Act of 1919. Now all 50 states and 50 districts of Columbia license real estate agents. This means that to conduct business as real estate agent in any state, you must be licensed by that state. In California, there are over 400,000 real estate licensees, more than in any other state. The state's licensing ability is an exercise of its police powers to enact laws within constitutional limits to promote public health, safety, and general welfare. Major provisions of law. California legislation has been compiled into a series of books called codes. What is commonly referred to as the real estate law is Division 4 of the Business and Professions Code. The real estate law has two parts. Part 1 covers licensing, and Part 2 covers transactions that includes the subdivided lands law. The complete text of all 29 volumes of the California Code, as well as information on bills pertaining before the California legislature, can be found at the following link. Real estate licenses are also subject to the regulations of Real Estate Commissioner. They serve to clarify and interpret the real estate law. They have the force and effect of law. The primary purpose of both the real estate law and regulations of the Real Estate Commissioner is to protect the members of the public with whom real estate licenses come into contact in their business activities. The California Department of Real Estate, DRE. The California Department of Real Estate, DRE, headed by the Real Estate Commissioner, administrators the real estate law in California. Every state has a similar department or agency responsible for enforcing laws concerning real estate licensing. Information about the Department of Real Estate, including the current status of all real estate licensees, can be found here. Now, just to remember as a side note on this, it's no longer the DRE, but they call it BRE, Bureau of Real Estate. The Bureau of Real Estate. The Real Estate Commissioner. The Real Estate Commissioner is appointed by the governor and serves as the governor's discretion. The person selected as commissioner must have been a practicing real estate broker in California for 5 years or engaged in some form of real estate activity for 5 of the past 10 years. The Real Estate Commissioner determines administrative policy and enforces that policy in the best interest of those dealing with real estate licenses. The responsibilities of the Real Estate Commissioner are highlighted in the following box. Assisted by the Department of Real Estate staff members, the Real Estate Commissioner screens candidates for license, conducts licensee disciplinary action, administers consumer recovery account, investigates non-licenses performing activities with a license is required, regulates non-exempt franchises and real estate property securities, prepares subdivision public reports. The real estate commissioner is appointed by the governor. To represent someone in a real estate transaction in California, you must be licensed by the BRE as a real estate broker or real estate salesperson, with some exceptions. A real estate salesperson, often referred to as a sales associate or associate licensee, can act only under the control and supervision of the responsible broker, that is, the real estate broker whom the salesperson is employed. The real estate broker is a business in which real estate licensees related activities are performed under the supervision of a real estate broker. A real estate broker may consist of only one broker of record and no employees. However, a brokerage may be large enough to have specialized departments with many salespeople, a support staff that includes administrative and clerical workers, and a number of branch offices. No matter how large a real estate office is or how its ownership is structured, there must always be at least one individual broker under whose license the real estate activities of the firm are carried out. This individual must be a natural person and not a corporation or other business entity or anyone acting under a fictitious business name. The real estate brokerage, sole proprietorship. A real estate brokerage that is a sole proprietorship may be owned by a licensed real estate broker, a salesperson, or a non-licensee. Real estate activities can only be carried out by or under the authority of a licensed real estate broker. However, no separate formalities are required to start a business as a sole proprietor. For business liability and tax purposes, however, most brokerages choose to incorporate. Corporation. A brokerage may be set up as a corporation provided that at least one officer of the corporation is a licensed broker and is designated the responsible broker officer. The corporation must submit the following to the DRE: the corporation licensee application and fee, a certificate of status issued by the Secretary of State within 30 days before submission of the application, or the articles of incorporation filed with the Secretary of State if a California stock corporation originally filed the articles within 6 months of the application. A statement of officers as filed with the Secretary of State. Partnership. A brokerage can be a partnership if at least one of the partners is a licensed real estate broker. Every partner who performs activities that requires a real estate license must be licensed as a real estate broker, but there can be only one broker partner of record. At least one broker partner must obtain an additional license for each branch office location. The partnership itself needs to be a separate license. Every real estate office conducts business only under an individual license as a real estate broker. A fictitious name is any name other than that of a real estate licensee. Use of a fictitious business name. Brokerages where there's a sole proprietorship, corporation, or partnership can do business under a fictitious name as long as the real estate license is in the name. First, a fictitious business name statement must be filed with the county clerk in the county of the broker's principal place of business address. The statement is effective for 5 years from December 31 of the year filed and is commonly referred to as a DBA, Doing Business As. Then, an original or legit copy of the DBA showing the filed or certified stamps from the county clerk's office must be sent to the real estate commissioner. The business cards of a real estate licensee should use exactly the same name that appears on the license. Note: the following requirements for fictitious business names also apply to internet domains used to identify a real estate brokerage or licensee. Often two or more real estate licensees work together to provide licensed real estate services as part of a team, group, or association. A team name is not considered a fictitious business name and does not require the filing a fictitious name business statement, as long as the team name includes surname or at least one of its licensee's members, and the team name does not need to be a term or terms such as real estate broker, real estate brokerage, broker, or brokerage, which would imply or suggest the existence of a real estate entity independent of a responsible broker. Advertising and solicitation materials must include the name and licensee number of at least one of the licensed members of the team, and responsible broker's identity must be displayed as prominently as the team name. As of July 1st, 2020, real estate licensees who changed their legal surname from the name under which the licensee was originally issued can continue to use the former name, and that name will not be considered a fictitious name. Both the new and formal names must be filed with the DRE/BRE. License inspection. A broker's license must be available for inspection by the commissioner or commissioner's representative as the broker's principal place of business. If a broker remains more than one place of business, each branch office must be separately licensed and the license must be available for inspection there. The license of any salespersons working for the broker must also be available for the inspection at the broker's main office. The broker-salesperson relationship. For the purpose of real estate law, a salesperson is always considered the employee of the broker. This means that the broker is held accountable for the salesperson's conduct in performing business activities. For compensation, tax, and other purposes, a salesperson can be treated as either an employee or an independent contractor. A salesperson's license is activated only after the name of the employing broker is provided to the BRE. The broker and salesperson are required by the real estate law to have written agreements. Regulation 2726 of the Real Estate Commissioner states, the agreement shall be dated and signed by the parties and shall cover material aspects of the relationship between the parties, including supervision of licensed activities, duties, and compensation. When a salesperson changes brokers, the following steps must be taken when the salesperson employment from one broker to another. Detailed information can be found at the BRE website at www.bre.ca.gov. The former employee broker must notify the Department of Real Estate Sacramento headquarters immediately in writing. The former employer must return the salesperson's license certificate within 3 days of termination of employment and sign the salesperson change of application. When a salesperson is discharged. If an employing broker discharges a salesperson for a violation of real estate law, the broker must immediately file a certified written statement of the facts with the real estate commissioner. The broker's salesperson contract typically will treat the salesperson as an independent contractor and will be a form produced by a trade association or private firm, making use of a form that has been prepared by one or more attorneys and is acceptable widely across state help to assure that the important points, including legal issues, are covered. The form may provide for mediation or any dispute between the broker and associate license for the binding arbitration of disputes. You should be alerted to the differences in the types of forms that are available, including those that appear here. The content of some forms is proprietary, which means the form is unique to the entity that created it. You will see a copyright notice on such forms, which indicates that you are not allowed to copy the form without permission or the copyright holder. Other forms consist of wording that is dictated by state law, what we refer to as statutory language. Even though the wording of the form is mandated, and even the style and size of die type used may be dictated by state law, the overall design of the form may still be copyrighted. Lastly, some forms combine state requirements and those of an association or company, Most of these customized forms are also copyrighted. When a salesperson is discharged, with the rapid changes of both California and federal law and updates of ongoing processes, by the time you see them, the forms of this book may already be revised. To keep up with the pace of the change, the two largest form publishers in the state have websites where form updates can be ordered and even downloaded for immediate use. The California Association of Realtors, headquartered in Los Angeles, has these forms. Activities of a real estate broker. The real estate law sets out the activities that require a real estate broker's license. Those activities also may be performed by a licensed real estate salesperson. The law defines a real estate salesperson as someone who is employed for compensation, salary, or commission by a licensed real estate broker to perform acts that require a real estate license. The salesperson can only conduct business as the employee of the broker. All the salespeople contracts with clients and customers will be executed in the broker's name. Real estate property transactions. The real estate law permits a real estate license, broker, or salesperson to represent someone else in any of the following transactions involving real property or a business opportunity: selling or offering to sell, including soliciting prospective sellers; purchasing or offering to purchase, including soliciting prospective purchasers; exchanging, soliciting or obtaining property listings for the sale or exchange; leasing, renting, or offering to lease or rent, selling, purchasing, or exchanging leases; filing an application for purchase or lease involving land owned by the state or federal government. The real estate law does not require licensing for the resident manager of an apartment building or complex, the manager or employee of the manager of a hotel, motel, or auto or trailer park, an employee of a property management company who merely opens vacant units to prospective tenants, and a real estate assistant who does not perform acts that require real estate license. The real estate law permits a real estate agent to handle transactions involving used mobile home or manufactured homes. The home must be registered in compliance with the Health and Safety Code and located in an established mobile home park or on a lot where it can remain for an uninterrupted period of at least 1 year, as allowed by local zoning ordinance or permit. A mobile home or manufactured home cannot be advertised as new. If these requirements are met, the agent can perform the following activities: sell, purchase, or exchange. If the real estate agent displays or offers for sale two or more registered mobile homes as the agent's place of business, the agent must also be licensed as a mobile home dealer. The requirements for that license, which is obtained from the Department of Housing and Community Development, are in the Health and Safety Code and can also be found on the website www.hcd.ca.gov. Mortgage loan transactions. In California, a real estate brokerage can also act as a mortgage loan brokerage. A real estate agent can represent someone in any of the following acts involving loans secured by real property or a business opportunity: soliciting borrowers for or lenders for a loan, negotiating loans, servicing loans, collecting payments, or performing other services for borrowers or lenders. In addition, the real estate agent can act as a principal party for the transaction in a transaction involving sales contract or promissory note secured by real estate in the following cases: purchase, sale, or exchange of such an obligation with a member of the public, consumer; servicing such an obligation by agreeing with a member of the public. As of January 1st, 2011, a licensee who acts as a residential loan originator (MLO) must register annually on the Nationwide Mortgage Licensing System and register, the NMLS. A DRE licensee who conduct mortgage loan activities for residential properties of one or more to four units must obtain an MLO license endorsement that is attached to the real estate license and renewed annually. Mineral oil and gas transactions. A real estate brokerage is permitted to handle the following activities involving mineral, oil, and gas properties for others: sell or offer for sale, purchase or offer to purchase, solicit prospective sellers or purchasers, solicit or obtain listings, lease or offer to lease, collect rent or royalties from such property or its improvements, exchange, assist or offer to assist in a filing of an application to purchase or lease a such property owned by the state or federal government. An exception is made from an officer or an employee of the state and the federal government. Mineral oil and gas transactions. A real estate agent can also act as the principal in a transaction involving one of the following: buying or leasing or taking an option on mineral, oil, or gas property for the purpose of sale, exchange, lease, sublease, or assignment of a lease or all of that property. Offering mining claims for sale or assignment. There is no longer a separate mineral oil and gas broker license. Any person who still has a MOG license is entitled to continue to perform the listed activities, but no new MOG licenses are being issued. Existing MOG licenses must be renewed and the renewal fees paid, but there is no continuing education requirements for MOG licenses. Business opportunity brokerage. As noted earlier, the real estate law allows agents or brokers to represent others in purchases of sales or businesses. A transaction involving a business opportunity includes buying assets that are a personal property, such as inventory, trade fixtures, and the business's goodwill. A business opportunity may also include or take the form of a franchisee agreement. A business opportunity transaction may involve transfer of stock. Ordinarily, a stock transfer requires a securities license as set out by the Corporation Code, but a stock transfer that is part of a transaction involving a business opportunity can be handled by a licensed real estate broker. Business brokerages is a growing area for real estate practice. In many areas, retail stores, restaurants, manufacturing, and other businesses make up a significant number of transactions every year. The SBA, a federal agency, defines small business as one with no more than 1 million in annual sales, or if a manufacturer with no more than 250 employees. In fact, 95% of U.S. businesses qualify as small business, and most of them change ownership every 5 to 8 years. Some brokerages specialize in business transactions, even limiting their activities to a particular type of business or size, such as retail stores or a certain square footage or annual gross income, gas stations, or warehouse storage facilities. Franchisees. A franchisee is defined in California's franchise investment law as a contract or agreement, either express or implied, whether oral or written, between two or more persons by which a franchisee is granting the right to engage the business of offering, selling, or distributing goods or services under a marketing plan or system prescribed in substantial part by a franchisor. The operation of the franchisee's business pursuant to such plan or system is substantially associated with the franchisor trademark, services mark, trade name, logotype, advertising, or other commercial symbol designating the franchisor or its affiliate, and the franchisee is required to pay directly or indirectly a franchise fee. Taking on and handling the business opportunity listing. The agent should evaluate carefully the business location and operation, as well as the seller's records and financial statements. Ideally, the business owner should provide profit and loss statements, or at least business tax reports for the past 3 years, for review by the buyer's accountant. Those documents are important because the business's income stream and assets will determine the selling price. The agent should be aware of all factors that might influence the soundness of the business as an investment. The prospective buyer may be an experienced business person, but often the business buyer will be young or inexperienced. The agent should be able to alert the buyer to federal, state, and local government requirements that must be met to obtain the necessary business permits, licenses, and clearances. In addition to federal withholding taxes, the buyer may be liable for sales tax, state payroll tax, withholding, and workers' compensation insurance. Successor liability is the obligation of a purchaser for sales tax that was not paid prior to the sale of a business. The buyer can be released from any obligation to withhold unpaid tax from the purchase price by obtaining a certificate of tax clearance from the California Department of Tax and Fee Administration. Uniform Commercial Code requirements. California has adopted the Uniform Commercial Code. The Uniform Commercial Code governs the sales or transfer of goods ordinarily held for sales in courses of business. Goods held for sale by a business probably were obtained on credit from a supplier or manufacturer. A bulk transfer of goods is a transfer of a substantial part of the materials, supplies, merchandise, equipment, or inventory that is not ordinarily course of the transferor's business. The Uniform Commercial Code protects creditors of the seller in such a transfer by requiring the notice of the transfer be given to the transferor's creditors. The notice is made once, at least 12 business days before the transfer is to take place. Notice is given by recordation with the county recorder, publication in a newspaper, or registered or certified mail to the county tax collector. Other requirements also may apply. In short, a business opportunity listing should not be taken unless the agent is fully informed of the business assets, liabilities, and is able to convey that information to purchasers. Because of the complexities involved in the sale of a business opportunity, some brokers will not allow an associate to handle this type of transaction. Prepaid rental listing service license. A prepaid rental listing service is a business that supplies prospective tenants with listings of residential real property on payment of a fee collected at the time or in advance of when the listings are supplied. Anyone licensed as a real estate broker may conduct a PRLS business without obtaining a separate license. The real estate broker must use a contract with the tenant client that is approved in advance by the BRE. Either the broker or the salesperson employed by the broker must be designated to supervise the PRLS activities. An individual or a corporation may obtain a separate 2-year license to conduct PRLS activities. Applicants must submit an application form, a properly completed fingerprint card, security in the form of a $10,000 surety bond or cash deposit for each location, and the appropriate license fees. The security requirement does not apply to the PRLS operated by a tax-exempt entity, an agency of the federal, state, or local government, or a real estate broker conducting a PRLS under a real estate license. Application requirements must be met for every location to be operated by the PRLS license. Before insurance of the PRLS license, the applicant must submit a copy of the contract to be entered into with the prospective tenants/clients to the BRE for approval. No examination is required. Exemptions from real estate licensing requirements. A real estate license is not needed by the following people: a person who deals with only their own property, the resident manager of an apartment building with 16 or more units, a corporation that performs any of the specific activities through one or of its regular officers who receives no special compensation for doing so, a licensed security broker or dealer involved in a sale, lease, or exchange of a business opportunity in that capacity. Anyone holding a duly executed power of attorney from the owner of property, an attorney at law rendering services in the performance of his duties, a receiver trustee in bankruptcy or a person acting under order of any court, a trustee selling under a deed of trust, employees of lending institutions, pension trusts, credit unions, or insurance companies in connection with loans secured by liens on real property or a business opportunity, escrow agents collecting funds in connection with loans secured by liens on real property, with the funds are deposited in the escrow agent's trust account. Other examples include cemetery authorities and person making fewer than 10 transactions. To provide more time for client and customer contact, many real estate licensees hire one or more assistants to help with the administrative and other tasks that do not require a license. Activities can be performed by an unlicensed real estate agent include the following: record filing, such as a rent, receipt, loan payments, or escrow sheets, meeting non-principals, such as the appraiser, home inspector, pest control, or fire inspector, computer data or retrieval, such as maintaining a client database or gathering title company records for the licensing client record files, word processing, such as downloading digital photos and graphics for flyer composition or distribution. It is important to note that unlicensed assistants cannot perform any of the activities that require a real estate license. Those activities are listed in the Business and Professional Code. An application for a real estate license must be honest and truthful. Conviction of a crime that is either a felony or involves moral turpitude may result in the denial of a license. Failure to reveal a criminal conviction or disciplinary action that occurred at any time in the applicant's history on an original license application may also result in denial of the license. Any fraud, misrepresentation, deceit, or material misstatement of fact in a license application can result in suspension of licensing without having within 30 days of issuance. The license or renewal application must provide a Social Security number to the DRE. This requirement does not apply to corporations with federal tax identification numbers. The DRE or BRE cannot issue or renew license if the applicant is on a list of persons who are delinquent in making court-ordered child support payments. This list is compiled by the Department of Child Services from information provided by the local child support agencies in California. The BRE will issue a 150-day license to the listed license applicant. If the applicant fulfills the other requirements, a regular license will not be issued until the release is obtained from the appropriate district attorney's office within 150 days. A current licensed individual who is placed on the list will be notified by the DRE by that. If the obligation is not cleared within 150 days, the license will be suspended. An application for a real estate broker's license must be at least 18 years old at the time of the license issued. The applicant must pass a qualifying examination and meet the following requirements for experience and education. The applicant must have been actively engaged as a real estate salesperson for at least 2 years of the 5 years preceding the application, or provide satisfactory proof to the commissioner of other experience equivalent to 2 years or full-time experience as a real estate salesperson. An applicant with a 4-year degree from an accredited college with a major or minor emphasis in real estate may be exempt from the experience requirement. As of January 2016, proof of legal presence is no longer required for applicants for a license renewal applicants, and applicants for payment of a real estate recovery fund. This means that, except as specified, any entity within the department may not deny licensure to an applicant based on citizenship status or immigration. The applicant must have also successfully completed 3 semester unit or equivalent college level courses in an accredited institution for higher learning or private vocational school approved by the commissioner. The courses include the following: real estate practice, real estate principles, real estate finance, real estate appraisals. The applicant must also have taken any 3 of the following: real estate principles, business law, property management, escrows, office administration, mortgage loan and broking, advanced real estate finance, advanced real estate appraisal. If both the real estate economics and general accounting are taken, only 2 courses from the second group are required. Attorneys and members of the bar of any state of the United States generally are exempt from the education requirements, but must have at least 2 years of real estate related experience to satisfy the 2 years full-time licensed salesperson experience requirement. and in either case must still pass the licensing exam. The applicant for a real estate salesperson license must be at least 18 years old at the time of license. The applicant must pass qualifying exam and meet educational requirements. Before taking the licensing examination, the applicant must successfully complete 3 college level courses in real estate principles, real estate practice, and one of the following courses: appraisal, property management, finance, economics, legal aspects of real estate, accounting, general accounting, business law, escrows, and computer applications in real estate. Members of the California State Bar are exempt from the college level course requirements. License examinations. The licensing examinations consist of multiple choice questions that are similar in format to the achievement examinations in this book, but much more complex, including lengthy fact situations with the same concepts covered from different prospects and different questions. The salesperson exam contains 150 questions, and at least 70% or 105 questions must be answered correctly to pass. Salesperson applicants have 1 3-hour session to complete the exam. The broker exam contains 200 questions, and at least 75% or 150 questions must be answered correctly to pass. Broker applicants have 4 hours to complete the exam. Written license examination is intended to show whether the applicant has sufficient knowledge for the required topics. The full term for brokers or salespeople license is 4 years. To renew the license for an additional 4 years, the licensee must successfully complete 45 hours of continuing ed. All courses must be approved by the DRE. For all license renewals, the applicant must complete 45 clock hours of education, including at least 18 hours related to consumer protection in addition to the separate 3-hour courses in the following: ethics, professional conduct, and legal aspects of real estate, agency relationships and duties in the real estate broker practice, trust fund accounting and handling, fair housing, risk management. E-licensing system is offered online by the BRE at www.bre.ca.gov. This can be used to expedite the sales process and renewals. Expiration and late renewal. If a licensee is not renewed before it expires, the licensee real estate activities must cease immediately. If the licensee of an employing broker expires, the consequences can be profound. Expiration of the employing broker's license will place all licensees, whether salespersons or brokers, who work for the employing broker on a non-working status. A license that is not renewed before it expires may be renewed at any time up to 2 years from the expiration date. A late renewal fee will be required. After the 2-year period, the licensee must qualify for and successfully pass the appropriate real estate examination. The real estate license number. BRE requires that all licensees have an identification number to be shown at every point of first contact with the consumer. The licensee license number must appear on material used to solicit customers, including the following: business cards, stationery, websites, promotional flyers, brochures, emails, leaflets, any time you come in contact with the consumer. The licensee license number must be in a typeset no smaller than the smallest typeset used in the solicitation material. If the name of more than one licensee appears in the solicitation, each person's license number must be disclosed. The license number of employing brokers or corporate brokers whose names, logos, or trademarks appear on the solicitation materials, along with the names of the licensees, numbers, and licensed employees for broker associates, need not appear on the material. In addition, the BRE license number a mortgage loan originator must include in an advertisement for a loan that is disseminated primarily in California, the unique identifier assigned to that licensee by the nationwide mortgage licensing system. Enforcement of real estate law. The Real Estate Commissioner investigates complaints regarding the activities of real estate licensees. The complaint may come from a member of the public or from a private group, such as a local association of realtors. The Commissioner is allowed to initiate an investigation and must do so if a verified complaint is made in writing by someone who believes he was wronged by a licensee acting in that capacity. DRE's investigation may include a statement by the licensee and examination by the licensed public records, bank records, title company, and public records. An informal conference including the parties may be held to determine the necessary for a formal hearing. If a formal hearing is held, it will be presided over by an administrative law judge. At that point, the commissioner becomes the complainant and the licensee is the respondent. The licensee may appear with or without an attorney. A person who has initiated the complaint is a witness. Other evidence may also be presented. Testimony is taken under oath. The most common violations of real estate law involve trust, fund, record keeping, and shortages, failure to supervise, unlicensed activity, misrepresentations, disclosure issues, and criminal convictions. Outcoming of the hearing. Charges are not proven by the evidence are dismissed. If the charges are proven, the licensee is subject to license suspension or revocation, depending on the seriousness of the charges. If the license is revoked, an application for reinstatement cannot be made for 1 year. When a violation involves an unlicensed individual, a cease and refrain order will be issued. Restricted license. In some circumstances, such as a violation of real estate law, the real estate commissioner may decide to issue a restricted license. The restriction imposed could limit the length of the license term, require for a salesperson employment by a particular real estate broker, or contain some other conditions such as filing of surety bonds for the protection of persons with whom the licensee does business. The holder of a restricted license cannot renew the license until the restriction is lifted. The commissioner has the right to suspend a restricted license without a hearing, pending a final determination after a formal hearing. The real estate commissioner also has the discretion to order one or more of the following penalties for violation of real estate law. Education, requiring the offender to successfully complete one or more courses such as a course in ethics, payment or fine, return of documents or other materials, reimbursement to the real estate recovery account for any amounts paid to victims or for the violation of the offender's behalf. The real estate law specifies many activities that can result in a suspension or revocation of a real estate license. Most prohibitive activities below are found in Business and Professional Code 10179. Misrepresentation. This is a statement or an act of deception on a matter of significance to the transaction, such as the condition of the property. Failure to disclose a property defect is probably the most common form of misrepresentation. False promise. This includes making any false promises of character to influence, persuade, or induce. An offer of a rebate or a gift to prospect clients is acceptable as long as the terms of the offer are express and fulfilled. Continued misrepresentation. This is a continued and flagrant course of misrepresentation or making of false promises through real estate agents or salesperson. Undisclosed dual agency. This is acting for more than one party in a transaction without the knowledge and consent of all parties. Commingling. This includes placing the licensee's own money in the same account with the money of others. The licensee can place up to $200 in account to cover account fees. Not specifying listing termination date. Any exclusive listing with an agent authorized by the real estate law must specify a definitive ending date. Making a secret profit. No compensation of any form may be received by the licensee without the knowledge of the licensee's client. This can happen when the licensee purchases property through a dummy buyer, then resells it at a higher price. Combining listings with options without informed consent of the seller. No option to purchase combined with a listing agreement is allowed unless the licensee profit is stated when the option is exercised and agreed to by the seller in writing. Dishonest dealing. This is any offer to conduct that constitutes fraud or dishonest dealing. Obtaining signatures of prospective purchasers of a business opportunity without owner's authority. No agreement to represent someone or receive compensation for a purchase, lease, rent, or exchange of a business opportunity can be obtained without prior authorization of the business owner. Willfully or repeatedly violating any provision of the Civil Code regarding real property transfer and disclosures. A real estate license may be suspended or revoked, or issuance of a license may be denied if the licensee or applicant, the person owning or controlling more than 10% of the corporation's stock, has engaged in any of the activities that are identified in the Business Code. Obtaining licenses by fraud. This includes obtaining a real estate license or license renewal by fraud, misrepresentation, or deceit, or making any material misstatement of the fact in an application for a real estate license, license renewal, or reinstatement. Criminal activities resulting in conviction. This includes suffering a conviction of a felony or a crime involving moral turpitude that is reflected for the qualifications or duties of a real estate license. False advertising. This is knowingly authorizing, directing, convening at, or aiding in the publication, advertisement, distribution, or circulation of any material false statement or representation concerning any business, business opportunity, or land or subdivision offered for sale. When advertising a property, a licensee must disclose that the property is offered through a licensed real estate agent. Failure to disclose this fact and provide the name of the license is called blind advertising and is illegal. Violations of other sections. This includes disregard or violating any of the provisions of the real estate law or the rules and regulations of the Commissioner regarding administration and enforcement of real estate law. 9 misuses of trade name. This includes the term realtor or any trade name or insignia of membership, such as the term realist, in any real estate organization of which the licensee is not a member. Conduct warranting denial. This is an acting in a manner that would have resulted in denial of a real estate licensee, such as conviction for a felony or a crime involving moral turpitude. Negligence or incompetence. This is demonstrating such carelessness or incompetence as a licensee that the interests of clients or customers are endangered. Negligent supervision of salesperson. This is failing as a broker licensee or broker officer of a corporation to exercise reasonable supervision of license activities of salespersons or the corporation. Violating government trust. This includes using one's employment by a government agency to violate the confidential nature of government records. Dishonest conduct includes engaging in any other conduct constituting fraud or dishonest dealing. Restricted license violation. This includes violating any of the terms of a restricted license. Inducement of panic selling. This includes soliciting or inducing the sale, lease, or listing of a sale or lease of residential property on grounds, wholly in part, of loss of value or an increase in crime or decline in quality of schools due to the present or prospective entry into the neighborhood of a person or persons of another race, color, religion, ancestry, or national origin. Conflict of interest. This includes a failure to disclose to a buyer represented by a licensee that the licensee or the person related to in a special relationship with the licensee has a direct or indirect ownership in the property. Manufactured mobile homes. Real estate licensees handling manufactured homes, mobile homes, are subject to general requirements and prohibitions acceptable to real estate transactions. In addition, real estate license law imposes the following restrictions on mobile home sales. A mobile home may not be advertised or offered for sale unless it is in a place in a mobile home park or located in a location where it can legally remain for at least 1 year. An advertisement of a mobile home must be for sale be withdrawn within 48 hours after receipt of notice that the mobile home is no longer available for sale, lease, or exchange.
Licensee or transfer of title fees may not be prorated unless the buyer and seller agree to the license that was required to pay for the fees to avoid penalties that would have been imposed for late payment. Only mobile homes that meets vehicle code requirements can be represented as transportable on the California highway. All material facts pertaining to equipment requirements must be revealed. A permit from the Department of Transportation or local agency must be obtained to authorize the moving of a mobile home. It may not be advertised or represented that no down payment is required if in fact the buyer will be advertised to secure an additional loan for that purpose. The licensee is responsible for making sure that the certificate of ownership or certificate of title of a mobile home is endorsed, dated, and delivered to the purchaser. No later than 10 days after the sale of a mobile home, a real estate broker must give written notice to the transfer to the headquarters office, Department of Housing and Community Development. The following are grounds for revocation or suspension of a real estate license: using a false or fictitious name or making false statements, failing to provide for a delivery of property endorsed certificate on title or ownership from seller to buyer, knowingly participating in a purchase or sale of a stolen mobile home, violating any requirement of the Health and Safety Code, Revenue Taxation Code, or Civil Code regarding mobile home registration, transfer, and taxation, submitting a check, draft, or money order to the Department of Community Development for any fee other than payment due to the state for which payment is refused. Licensee conduct. Every licensee should have a copy of the reference book Real Estate Guide published by the BRE, available at www.dre.ca.gov/publications. The latest 2010 edition lists examples of unlawful conduct by real estate licenses. Examples of unlawful conduct in sale, lease, or exchange transactions: knowingly making substantial misrepresentations of the likely value of real property, its owner either for purpose of securing a listing or for the purpose of acquiring an interest in the property for the licensee's own account. A prospective buyer for the purpose of inducing the buyer to make an offer to purchase the real property. Representing to an owner of real property when seeking a listing that the licensee has obtained a bona fide written offer to purchase the property, unless at the time of the representation the licensee has possession of a bona fide written offer to purchase the property. Stating or implying to an owner that real property during listing negotiations that the licensee is precluded by law, by regulation, or by the rules of the organization other than the broker firm sending the listing from charging less than the commission or fee quoted in the owner by the licensee. Making substantial misrepresentations regarding the licensee's relationship to an individual broker, corporate broker, or franchise brokerage company, or the entity's persons responsible for the licensee's activity. Knowingly underestimating the probable closing costs in a communication to the prospective buyer or seller of real property in order to induce that person to make or accept an offer to purchase. Knowingly making false or misleading representation to the seller of real property as to the form, amount, or treatment of a deposit towards the purchase of the property made by an offerer. Knowingly making false or misleading representation to a seller of real estate property who has agreed to finance all or part of the purchase price by carrying back the loan. Making an addition to or modification to the terms of an instrument previously signed or initialed by a party to a transaction without knowledge and consent of that party. A representation made to a principal or agent to a prospective purchaser of a promissory note secured by real estate property about the market value of the securing property without a reasonable basis believing the truth and accuracy of that representation. Knowingly making false or misleading representation or statements without a reasonable basis for believing its truth. The nature of and of the condition of an interior or exterior features of a property when soliciting an offer. Knowingly making false or misleading representation without a reasonable basis for believing its truth, size, or parcel, making false or misleading representations to the buyer or lessee of real property without a reasonable basis to its truth. When acting in the capacity of an agent in a transaction for the sale, lease, or exchange of real property, failing to disclose to a prospective purchaser or lessee facts known to the licensee materially affecting the value or desirability of the property. When the licensee has reason to believe that such facts are not known or readily observable by a prospective purchaser or lessee. Willfully failing, when acting as a listing agent, to present or cause to be presented to the owner of the property any written offer to purchase received prior to the closing of sale, unless explicitly instructed by the owner not to present such an offer, or unless the offer is uh, frivolous. When acting as the listing agent, presenting competing written offers to purchase real property to the owner in such a manner to induce the owner to accept the offer that will provide the greatest compensation to the listing broker without regards to the benefits, advantages, or disadvantages to the owner. Failing to explain parties or prospective parties to real estate transactions for whom the licensee is acting as an agent the meaning and probable significance of a contingency in an offer or contract that licensee knows or reasonably believes may affect the closing date of the transaction or timing of the vacancy of the vacating of the property by the seller or its occupancy by the buyer. Failing to disclose to the seller of real estate property in the transaction in which the licensee is an agent or the seller the nature and extent of any direct or indirect interests that the licensee expects to acquire as a result of sale. Exercise. A broker opened a real estate brokerage office and immediately hired a salesperson. The salesperson printed and circulated a newsletter throughout the neighborhood. This salesperson gave a few mortgage loan stats in the newsletter and stressed the record high property values in the area, concluding with this statement, quotes, "I have never handled a listing I couldn't sell," when in fact the salesperson had never handled any listing, as the salesperson violated the code of ethics as the broker. And we would say absolutely yes in this situation. You cannot advertise something that's false. In this case, the falsity would be that this agent has never ever had a listing before. Better to be honest at all times. Desirable conduct. Recommended conduct in sale, lease, and or exchange transaction. The real estate licenses are encouraged to adhere to the following suggestions in conduct and their business activities. Give a high level of competent, ethical, and quality service to buyers and sellers in real estate transactions. Stay in close communication with clients or customers to ensure the questions are promptly answered and all significant events or problems in the transactions are conveyed in a timely manner. Cooperate with the DRE. Use care in preparation of any advertisement to present an accurate picture or message to the reader, viewer, or listener. Submit all written offers in a prompt and timely manner. Keep oneself informed of current on factors affecting the real estate market in which the licensee operates as an agent. Make full, open, and sincere effort to cooperate with other licensees, unless the principal has instructed the licensee to the contrary. Attempt to settle disputes with other licensees through mediation or arbitration. Advertise or claim to be an expert in the area of specialization in real estate. Strive to provide equal opportunity for quality housing and high-level service to all persons regardless of race, color, sex, religion, ancestry, physical handicap, marital status, or national origin. Base opinions of values, whether for the purpose of advertising or promoting real estate brokerage business, upon documented objective data. Make every attempt to comply with the guidelines for professional conduct and code of ethics of any organized real estate industry group with the licensee is a member. The DRE performs many functions in addition to regulating business activities of brokers and salespersons. Through education and research, account research and land and use real estate development is made possible at both public and private universities and research entities throughout the state. The Consumer Recovery Act is another fund funded by licensee fees. It's available to aid victims of licensee fraud, misrepresentation, deceit, or conversion theft of trust funds, who are awarded money damages by the court or as a result of a DRE administrative proceeding that are non-collectible. The victim must have made a reasonable effort to collect the amount awarded from the licensee, assets, and all other properties involved in the transaction that may be liable and able to pay the victim. The victim may apply for payment to the DRE within 1 year after the judgment becomes final. The licensee has an opportunity to respond to the allegations and to object to the payment of a claim. A maximum of $50,000 per transaction or $250 per licensee can be paid from the consumer recovery account. Reimbursement to the fund by the offender will be required as part of the disciplinary process, and offender's real estate licensee is suspended until full reimbursement. Professional associations. The best way for the real estate licensee to become involved and remain enthusiastic about the profession is to become a member of the professional association. Trade associations provide sources of information, training, and contact with other professionals. Associations also help shape the law in the industry by establishing and enforcing standards of practice and also by providing an effective voice for their members. The term realtor is a registered trademark of the National Associations of Realtors, NAR, and may be used only by realtor members. Realtus is another member designation of the National Association of Real Estate Brokers. This group was formed in 1947 in Tampa. The Asian American Real Estate Association was founded in 2003. The National Association of Hispanic Real Estate Professionals, a voice in Hispanic real estate, has more than 70 chapters throughout the United States. Most local real estate associations are affiliated with state and or national organizations. Local organizations bring members together to assist in community outreach as well as charitable programs. And of course, you can see right here on this list, there are the different trade associations. The one that you're going to be most familiar with and using a lot are obviously the BRE, also known as the DRE, the Association of Realtors, California Association of Realtors. All right, we've made it to the end of the lecture. So here's our summary. The business of real estate entails many responsibilities for the licensee. Responsibilities begin with completing qualifying courses and passing the examination. They also include the obligation to make sure that the licensee obeys both real estate law and the regulations of real estate commissioner. The foundation of all these activities and requirements of the California Department of Real Estate is the element of fair dealing. We have come far from the days when the concept of caveat emptor served as a shield for the unscrupulous. Now the police powers of the government have brought the real estate law found in the Business Professions Code. The Real Estate Commissioner and the Department of Real Estate are charged with the task of supervising the education, listing, and conduct of those who call themselves real estate professionals. All right, good work. We'll see you in the next chapter.